Hello my friends, I am Humberto Fernandez, and I know that reviewing a promise of sale contract on real estate can be a little bit confusing, especially if you don't come from a legal background. So today I'm going to tell you which are the key points that you need to pay attention to when you are up to this task. Stay with me. So before we begin, just to point out that promise of sale contracts can be very different one from the other. It depends a lot on who's the lawyer drafting them and also who's the developer issuing them. However, they all share some common aspects, and that's exactly what we're going to be covering in today's video. So the first thing that you're going to find in your promise of sale contract is the objective of the contract itself. This part is actually pretty much self-explanatory, as it just points out who is selling what to whom, and that is a common aspect that you will find on every promise of sale contract. The next part that you may or may not find is a lot of background. Some lawyers decide to put in their contracts all of the background of how they say what's the story of the property that you are acquiring, when the lot was purchased, when the building license were obtained. However, all of this background is actually going to be contained in the title. So that portion, usually some lawyers just put it because it resembles a little bit more what a title should look. However, some contracts are pretty short and they do not include all of this background. So you may or may not find an extensive background about the property and also the developer. And this is the part actually where sometimes the contracts get a little confusing because some lawyers decide to put every bit of background about the property and it can get long. So in shorter contracts, the point is you are not going to find all of this background, or you're just going to find like a brief description of how the property was built, let's say the story of the building that you are acquiring. But again, keep in mind that this background, you may or may not find it on the promise of sale contract, but you for sure are going to find it on your title. The next portion of the contract that you're going to find and that you really need to pay attention to it is about the personal information, both yours and of the seller. Here, really, the lawyers can choose a little bit how much information to include. However, what it is important is that the information contained in the contract is enough to make a very specific identification of both of the parties. This information can contain, of course, your name, your address, phone number, email, and some other background information. Sometimes they ask if you're married or not. So again, the length of the information that is going to be contained in that part, it depends really in the taste of the lawyer. However, what you need to keep in mind is that there need to be enough information to unequivocally identify both of the parties, and that's the part that you need to pay attention. Of course, check that your name, your address, and your ID number and all of that is correct. You need to pay attention to that. And obviously, on their side, the developer should provide you with information or pieces of ID that actually you can compare to the information contained on that contract, such as construction licenses or incorporation acts. All of that information, you need to take a good close look to that information. The next portion of information you need to pay close attention to is to the description of the property. Here you will find information such as the unit number, the square footage, whether or not it's furnished or not. The property usually tend to be very detailed, and more often you would find that developers will also attach an annex to the contract with the floor plans and more detailed information. However, in this part of the contract, it's just very important that you check out that everything matches, that the square footage matches, and of course, if it's furnished, not equipped or not, all of the details that you have discussed in your negotiations and that should be placed on your offer should be also contained here so that, again, you unequivocally can absolutely pinpoint that the property that you are buying is the one that you want. And following, this is actually the core of the contract, which are the terms of the sale. Here you need to pay attention, and very close attention, to the price, of course, but then also about the installments that you're going to make, and very important, the dates. This information needs to be absolutely clear and you need to review it because if the price is not right or anything else, it can get a little bit problematic. So please, my friends, pay close attention that the price is right, that the dates in which you're going to make installments are also right, that the amounts of those installments actually add up, and obviously the remaining amount that you're going to leave to the titling, everything needs to add up. In this part, my friends, I need to stress it. Pay close attention, bring your calculator and do your math just to check that everything is okay, because numbers can get complicated, and this is a part of the contract where we usually find a lot of mistakes, and those mistakes are really not just embarrassing, it can also get a little bit problematic. So before signing anything, just pay close attention to this little part of the contract, which is absolutely important. And following the most feared part of the contract, which are the penalties, which in this case, and I'm going to offer just my own personal opinion on this thing, I really don't consider them to be penalties, because we need to understand that contracts are signed on good faith, either of the parties, or we cannot assume that either of the parties are looking forward to penalize the other party. So I like to think about them as warranties of fulfillment, meaning what is going to happen if either of the parties do not live up to the terms of the agreement. So in this part, you will always find that there is some monetary, some financial penalization for either of the parties that breach the contract. Now, there is something very important that you need to pay attention. If you feel that those warranties of fulfillment are a bit abusive, then they probably are. The laws state that no one can profit out of penalties. So I'm going to say that standard in the industry, and I'm talking about Mexico, you may see that the penalties can be somewhere between 10 to 20% of the total value of the operation in case either of the parties do not fulfill the agreement, meaning that either whatever party that breached the agreement needs to bring the money back to the other party plus that percentage. So if that percentage is over 20%, most likely is not a very good contract, and you should be paying attention to that. The important thing is that the amount on these warranties of fulfillment is that the amount is enough to warranty the fulfillment, but not that much that actually you would be making money out of the penalty. So this part is a little bit subjective. However, you need to pay attention, and really you need to understand that the objective of these clauses, of these guarantees of fulfillment, is not to actually make you, stumble and get your money or something like that. It's really just to warranty that both of the parties live up to their agreements, and that's the whole spirit of this part of the penalties. So my friends, I hope this little guide help you to look around in your contracts, to give you a little agenda as for which are the key points that you need to pay attention when you're reviewing the contract. And as always, please don't forget to like, don't forget to subscribe. That helps this channel a lot. And thank you, my friends. To the next one.